Hello. The concept of sanctuary, a place of refuge offering immunity, has a long history. In the Old Testament book of Deuteronomy, Moses is directed to designate 6 cities of refuge, that the slayer might flee thither, which should kill his neighbour unawares, and hated him not in the past, and that fleeing unto one of these cities he might live. In the Eumenides by Aeschylus, after killing his mother Clytemnestra, Orestes finds sanctuary at the Temple of Apollo at Delphi. A limited system of temple asylum was a feature of ancient Rome. A law of Theodosius in AD 392 defined the right to sanctuary in churches. In Anglo-Saxon England, the late 7th century law code of Ina, King of Wessex, which we looked at in part 1, directed that if anyone be guilty of a capital crime and flee to a church, let him have his life, but let him make satisfaction as the right directs. The late 9th century laws of Alfred the Great decreed that every consecrated church had the privilege of providing respite from pursuit for 7 nights, and anyone failing to observe this incurred the penalty of breaking the king's protection and the church's peace. The aim of the process was to provide a breathing space, during which negotiations to resolve an issue, perhaps by paying compensation, could take place, and avoid a feud escalating. Under King Athelstan, 9 days respite were allowed. Following the Norman conquest, changes were introduced, limiting the number of times an individual could claim sanctuary. Over time, the system evolved further, with the extension to 40 days of the time sanctuary could be claimed, during which, by making a confession of guilt before a coroner and swearing to leave the country, in the legal phrase to abjure the realm, a trial could be avoided. The local community was supposed to guard sanctuary seekers to prevent their escape and supply them with basic provisions during the 40-day period of grace allowed. Ecclesiastical sanctuary applied to all churches and typically began at the church door, although there are traditions of grasping a sanctuary knocker or haggaday, for example at Durham Cathedral and Holy Trinity Church, Stratford-on-Avon, or ringing a bell. Sitting on a frith or peace stool, as at Hexham Abbey, was a practice at some churches. There were also more than 20 secular franchises in medieval England where sanctuary could be claimed. These required a royal charter, and a church was frequently the focus of refuge, but the boundaries might extend a mile or more beyond, with the limits marked by boundary crosses. The remains of this boundary cross is one of 4 that defined the former limit of the liberty and sanctuary of Beverley Minster. Subject to a confession and agreement to banishment, a sanctuary claimant was allowed to leave, barefoot and bareheaded, and this was an age when everyone wore a hat. Carrying a wooden cross, they were required to make themselves from what they could find in the churchyard to indicate they were under the protection of the church, and keeping to the King's Highway, make their way to a designated port. They were given a set number of days to do so, and not allowed to stay more than 1 night in any place along the way. Port authorities had the power to force a ship's captain to give them passage. One wonders how many miscreants vanished into the forest and the perils of outlawry on their way to a port. Outlawry meant exactly that, beyond the protection of the law, and liable to be killed on sight. Technically, women were made waif or waived rather than outlawed, but it amounted to the same thing. A bounty of 5 shillings could be claimed for the head of an outlaw, the same as the bounty for a wolf's head. How many fugitives from justice were pursued by vengeful injured parties, or disappeared overboard once a ship was out of sight of land, we can only imagine. Those who arrived as penniless strangers in a foreign land will have faced hostility. Patchy survival of coroners' records limits the information available on the use of sanctuary. In the year from April 1271 to March 1272, 20 cases are recorded for Staffordshire, one of the smaller English counties in terms of population. They involve both men and women. The value of their chattels, the movable property owned, which was forfeit to the Crown, varies between nothing and 5 shillings and a penny. These are poor people. In most cases, the local community, the vill or township, were found in mercy, meaning they were fined for not making an arrest before the accused reached sanctuary. Most of those who abjure the realm vanish from history. I found one example of a doctor accused of murder who claimed sanctuary, confessed and agreed to abjure the realm in 1288, who returned to England with a royal pardon, having tracked down and gained access to Edward I on campaign in Flanders. Sanctuary was disallowed for treason in 1486, after the Battle of Bosworth field the previous year, and restricted in 1540 to just 8 regional locations: Derby, Chester, Launceston, Northampton, Norwich, Wells, Westminster and York. It was finally abolished under James I in 1623. Next time, trial by ordeal, trial by battle and trial by oath. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.